So welcome to this event. This event will look at how to overcome the challenges posed when bringing damages claims against public authorities. The panel will discuss fixed recoverable costs, probate issues when bringing a claim under Article 2 of the European Convention on Human Rights, as well as discussing leave under Section 329 of the Criminal Justice Act. Actually, I'm not sure.
No, it's 139.
139 of the Mental Health Act 1983. So sorry about that. Nobody is talking about that today, but that is something we do know about if you wanted any tips on that as well. We have a fantastic lineup of speakers today. We have Sarah Hemingway, who is a barrister at Garden Court, obviously. She regularly represents claimants in civil jury trials. A major part of her practice involves civil claims against public authorities, with a particular focus on actions against the police. She is experienced in jury trials involving false imprisonment, assault, malicious prosecution, and other torts, and regularly advises on similar claims. We then have Simblet KC, another barrister at Garden Court Chambers, and his practice focuses on individual rights in 4 discrete areas. These are civil claims against the police and public authorities, inquests, mental health and court of protection, public law and judicial review. Stephen specialises in claims for false imprisonment, assault, malicious prosecution and misfeasance in public office, against the police, prison authorities and psychiatric hospitals. He was one of the lead advocates representing bereaved families in the Hillsborough inquest and has appeared as advocate in a number of public inquiries. And last but not least, Stephen Clark, another barrister at Garden Court Chambers. He specialises in complex multidisciplinary work across judicial review, immigration and asylum, inquests, actions against state authorities, prison law and community care, and he acts in the full range of civil work against public authorities and in complex inquests across detained and community settings.
So I'm going to be speaking to you about probate issues once you've had an inquest and you're looking to bring a civil claim in relation to the death. I understand that a handout is going to be provided after the talk. The slides that I'm going to whiz through today, I'm going to speak for about 15-20 minutes, are a honed down version of those slides that you'll get on the handout. So there will be more notes that are provided after this talk. Both Chris Williams and I do a lot of inquests. We do the civil claims following the inquest. So Chris Williams, another barrister from Garden Court Chambers, has had some input into this presentation as well. Basically, the aims of the training are to give an overview of avoiding strikeout and wasted costs, which is probably of interest to a number of you. Obviously, that's not an ideal position to be in, but it's a position that you can quite easily find yourself in by not paying attention to those basic steps that need to be taken prior to issuing a claim on behalf of the estate and on behalf of other claimants. I want to talk about why grants of probate or letters of administration are essential to the pursuit of an Article 2 claim on behalf of a deceased estate, and the difference between probate and letters of administration. There are inherent delays in relation to obtaining both of those, and so it's important to understand how long that process takes and when you need to get that done. And obviously, those protective steps are best done at the earliest opportunity, as soon as you are instructed. So firstly, mechanisms for bringing claims on behalf of a deceased estate. You've got 3 basic statutes that you need to look at. First is the Law Reform Miscellaneous Provisions Act 1934. I think it's Article 1, says that any claim that is open to the person who dies, if there's an ongoing claim in relation to that person at the time of death, that then continues and somebody is able to continue that claim for the purposes of the estate. So for instance, if they were in the middle of a neighbourhood dispute and they were complaining about the fence, if they died during the course of those proceedings, then whoever is beneficiary of the estate, or administrator or administratrix of the estate or executor, can carry that on in that person's name, even though they're deceased. Obviously, when we're talking about inquests, the person has died, and what you're looking to bring is a claim for either negligence or human rights, or whatever that claim is, abuse, then an assault or whatever. The person's died, and you are, as the administrator or the executor, you are then continuing that claim on behalf of that person who's died and the estate. So it's their estate that you are claiming on behalf of. The Fatal Accidents Act 1976, that is the act that you bring the claim for family members and dependents. So if the person dies, has children, then those dependents have a claim in relation to the monies that they would have spent on them during the course of their lifetime. So a young person, a child, would be able to say, well, you know, they were bringing in so much a month, it was paying for my education, it was paying for my food, it was paying for clothing, all of that. That then becomes a dependency claim, and that becomes part of the claim, but it's under the Fatal Accidents Act that claim is brought. And thirdly, you've got the Human Rights Act 1998. You've got the direct victim, which is the deceased themselves. So if what you're looking at is an Article 2 claim because they ultimately died, you're looking at what happened to cause that death. The deceased has that claim, you bring it under the Human Rights Act, that continues post-death. And indirect victims, that's the claim that is brought on behalf of the family members who have lost their loved one. And they are indirect victims, provided that they do share that bond, and they've got to be close. That relationship between the deceased person and the family member has to be close enough so that they can be seen as a victim of a breach of Article 2. And as you can see on the slide there, all persons claiming as indirect victims must be listed in the claim in their own right, in addition to the estate. So what the header of the claim would look like is that you've got a claim brought against the prison service, the MOJ, the police, whatever the defendant is. But the claim is brought firstly on behalf of the estate of Mr. X, Mrs. X, and the following claimants: the spouse, the children, whoever is claiming in their own individual right. That will all be part of the heading. So wills and intestacies, there's clearly a difference. One person dies, they have a will, you apply for a grant of probate, and the person then who is executing the will is the executor. If somebody dies and they don't have a will, which often is the case when you are representing people who have been in police custody, in prisons, we know that they often don't have a will. They often don't have an awful lot to leave in a will. And so you have somebody that dies, they're intestate, and the person who is going to be managing any claim in relation to the estate or on behalf of other indirect victims will be called the administrator or administratrix. And they need to apply for letters of administration. Now, one case in which that happened, Milburn, Snell and Evans, 2011 case, that was where a man died intestate, didn't have a will, and his 3 daughters wanted to bring a claim in relation to a farm. Now, the deceased had been in a relationship with a woman for about 17 years, I think, so they were living as spouses almost, and she had the farm when he died. And the daughters, his daughters, brought a claim in relation to a part of that farm. Given that they made the claim before they got letters of administration, the claim was declared a nullity. Now, they tried to appeal that. They tried to go to the court and say, well, hang on a minute, although we didn't have letters of administration at the time, we've now got them. But the Court of Appeal said, well, no, actually, the fact that you didn't have them at the start when you issued the claim means that this is a claim that was dead in the water at the very start. You can't breathe life into it by now saying you've got letters of administration. That's done, and it cannot be rectified. There were claims that came subsequently to that. There's one called, I've got it here, Mira against Al-Baho, which was a 2015 claim. Judge Peter Smith in that case said, well, hang on a minute, you've got, although you might not be able to remedy it through CPR 19.8, which is all about, you cannot bring a claim unless you've got administration, letters of administration in place. He said, well, hang on a minute, you've got CPR rule 3.10. And in that, a court can use its discretion to remedy failures to comply with rules or procedure, provided it's just. And he said, well, this is a case where these three daughters have a legitimate claim to some of the value in the farm. They're seen as beneficiaries of the farm, of the estate of their deceased father. They didn't get the letters initially, but we can remedy that. It would seem like a just way to do that. And he was dealing with a similar kind of case at the time. And so he says that that's the answer, CPR 3.10. Now, there was a further case, a case called Maridive, where Judge Mance said that, hang on a minute, no, you can't do that. It's not so broad. You can't remedy everything. That's for rules, procedures. Where you've got a claim, and what they were dealing with in Maridive, was that there had been a claim, there'd been a defence, and in the reply to that defence, they effectively initiated a new claim. So it's out of time, and what they used up Rule 3.10 for was to say, right, well, we'll remedy that. We'll say that, okay, well, it's irregular, but this wasn't a nullity to start. The claim was validly issued in the beginning. We've got this irregular procedure. We can remedy that through Rule 3.10, but it's not the same as a claim that was issued without letters of administration. There was a nullity from the start. So what Smith J was talking about in Mira Al-Baho, we don't agree with that. He got the law wrong. So that kind of little inkling of hope that people might have in cases like ours, where you've got a case and it's been issued and you haven't got letters of administration. Some people have tried to rely on Mira Al-Baho, but really you can't do that. It's been shown not to be good law. And then more recently, we've got the case of Jennison against Jennison. And that was a case where in New South Wales in Australia, somebody died. Letters of administration, actually probate. This was a case where the deceased had a will. A grant of probate was issued. And many years later, the deceased's wife tried to bring a claim in England and Wales. And so the grant of probate was reissued for the purposes of the claim here in this country. And what the court said in that case was, look, the actual standing of the claimants in that case emanates from the will itself. It doesn't emanate just from the grant of probate. Unlike a case where you've got somebody that dies intestate, it's the letters of administration that actually give the claimant standing. So in a case where somebody has died, they've got a will, they haven't got grant of probate in place, claim has been issued, it's not so detrimental to the claim that you haven't got grant of probate in place before that claim is issued, because you've got the will, and the will name the executor has standing to bring claims. But what everybody says in relation to that is don't use that as a fallback. If you've got somebody that's died, even if they've got a will, get that grant of probate in place before the claim is issued. But you don't want to be having to argue this later on when the defendant turns around and says, well, hang on a minute, did you actually have standing to be able to bring this claim in the first place? Was probate properly issued? So then we've got the Human Rights Act. Obviously, most of us will know about time limits. We'll have come across this in many other circumstances, not just in inquest civil claims. We know you've got 1 year from the date of the act complained of, or such longer periods as the court thinks equitable, having regard to all the circumstances. Again, you don't want to be relying upon that. You want to be able to get your claim issued within that 1 year period. That's something to balance when you're looking at somebody coming through the door. They've got an issue. Loved one's died. You want to get the claim issued as quickly as possible because you don't want to be falling foul of this 1 year limitation period. You think you've got an Article 2, an Article 3, an Article 8 claim. You're going to want to issue the claim protectively, but balance that with getting letters of administration in place, getting probate. At the moment, I'm told it's taking about 16 weeks at least to get those documents in place. It can take a lot longer. So that's something to bear in mind. The other thing you need to do as well is identify all the potential claimants. So where somebody has died in prison, I had a claim recently where somebody died in prison, ex-partner and child were proper victims, claim was issued in relation to them. And as we progressed with that claim, it became evident that actually, as his sister told us, he had other children as well by a different partner. And so the obligation then falls upon the solicitor to seek those other potential claimants out. There's a duty to do that because there can only be one claim. And everybody who is a potential beneficiary must have an opportunity to be able to be added to that claim, be a potential beneficiary. And either say yes or no to being included on the claim form. That can be difficult. 2 of these additional children were still children. One of them was an adult and had moved away, was difficult to get hold of. Even when we did get hold of him, it was very difficult then to get instructions from him. And when you're playing with time limits, it's sometimes a tricky position to be in because you don't want it to negatively affect your instructing claimants. So you do want to protectively issue on behalf of everybody that would have a potential claim. Part of that, as we know, is writing to potential defendants, getting something in writing to stay the claim pending the outcome of the inquest, or getting written agreements that they're not going to bring a limitation point. A separate point is about, well, what do you do when you've had the inquest, you think you've got an Article 2 claim, and the outcome isn't as positive as you thought it might be. So you haven't got causation on death, you haven't got an Article 2 claim, that's been blown out of the water depending on what the jury have returned in terms of their conclusions. You can still look at Article 3 or Article 8 claims. So Article 3, this comes from the case of Keenan against the UK. This is where a man was found hanged in his cell. And although it wasn't found that the failings of the prison were causative of death, there were clear indications that the prison, whether that be the healthcare or the prison staff, had failed to protect his rights in relation to Article 3. So the treatment that he received in relation to mental health had fallen below the standard and met the Article 3 inhuman or degrading treatment threshold. And so the family were awarded damages in relation to that, as was he and the estate. And similarly, in relation to Article 8, the case of Bensed against the UK, where your claim might not meet the Article 3 threshold, it still might meet the Article 8 threshold in that Bensed said mental stability comes within that Article 8 private life definition. So those are 2 other cases that can be, sorts of claims that can be looked at. Now, just in terms of practice, I know one of my best instructing solicitors have a lot of claims like this, and I know now that they have a policy in place that no claims are brought on behalf of people following inquest or in anticipation of an inquest without grant of probate or letters of administration actually being on the file. get them in place, because a lot of members, family members, when they're grieving, when they've just been through one of the most traumatic periods in their life, have a lot of things to deal with. They've got legal aid forms to deal with, they've got all sorts of things going on, and they're not necessarily focusing on the, ticking all the right boxes, getting all the paperwork in place that they need to. And I know that in some cases people have said, yeah, that's all in place, when it hasn't been, and you do actually need to get that evidence. You need it on the file, and having a policy whereby you don't issue a claim until you've got that on file is, I would say, an example of best practice, and that will avoid some of the pitfalls that you can otherwise come across. I think that's pretty much everything. How am I doing for time? I wasn't.
If you wanted a couple of minutes, yeah.
We don't have to sing a song to put it out.
I'm just looking at my fuller notes to see if there's anything else that I want to put in, but I think that's pretty much it. I think I've covered everything.
Thank you.
Right, well, although the theme of these talks are basically, well, we put avoiding procedural pitfalls. Really, we mean avoiding complete disasters, wasted costs orders, liability under insurance policies and things like that. And one of the biggest potential pitfalls to fall into is if you're bringing a claim under section, or where you need leave under section 139 of the Mental Health Act. I saw on the blurb for the talk that it had been put down originally that it was going to be a talk on section 329. I think that the other disaster that has been seen off is that Stephen Clark's going to talk about how to get paid for your work and be able to recover the cost for it, which would be another disaster. But I will try, since I've done the section 139 talk, I'll try and compare it to 329 as we go through, because there are some important differences and it's worth knowing about. Leave under section 139. This is a long-standing legislative protection. When we go back and look at the case of Seal, you'll see the Supreme Court, I think it was House of Lords, reviewed all sorts of litigation, all sorts of the Mental Health Act going back into the 50s, I think to the 19th century, where there's always been some sort of, not immunity, but protection of people involved in providing care and treatment to mentally disordered people. And the current incarnation of that provision is in section 139 of the 1983 Act. And I've set out there section 139(1), which shows essentially no person shall be liable, and then all the other things, unless the act was done in bad faith or without reasonable care. So you see there that it covers not just actual performance, but not just actual compliance, but also purported performance. That's one of the things that we see in the section, and purporting to be done. And also it elevates, or can, I mean, in practice it may not, because of the provision, as we see, that the things that don't apply to those detaining people in hospitals, but it may, in certain circumstances, change the substantive test for liability, because essentially the threshold is set out by statute as unless in bad faith or without reasonable care. So there may be certain circumstances where somebody might have been strictly liable, where because of section 139(1), they're only liable if you can prove that it was in bad faith or without reasonable care. But I'll move to the next slide, because this is the need for leave, and this is where things can go disastrously wrong, because section 139(2), I've set it out there, provides a bar to bringing prosecutions in certain circumstances, and for our purposes, no civil proceedings shall be brought against any person in respect of any such act without the leave, and they still use that term, of the High Court. Now, this next bullet point is an important one. It does not apply to claims against hospitals because of section 139(4). So if you're suing, for example, a hospital for falsely imprisoning your client, you do not, in fact, need to obtain leave. But for every other purpose, and bear in mind that under the Mental Health Act, quite often it's a particular person who has a statutory position rather than the hospital necessarily being liable for that person, you will require leave. Consequence, if you don't get leave, well, the top bullet point is the one you need to know. It's a disaster. It's on the same footing as if in Sarah's talk you brought proceedings where you needed a grant of probate or letters of administration and you didn't have them. The claim is a nullity, and it can the harshness of this provision and the potential for injustice that it creates is demonstrated by Seal and Chief Constable of South Wales, which is a case that went all the way to the House of Lords, where essentially somebody had objected to his neighbour blocking his car in. There was a sort of noisy dispute, the sort of thing that might lead to there was some sort of altercation. The police were called and he was detained in the street. He brought proceedings, but right at the very end of the limitation period, and he hadn't got leave. And the defendant took the point that the police officers were purporting to act under the Mental Health Act, and that the failure to obtain leave was fatal to the claim. And the House of Lords decided by a 3-2 majority that there was no jurisdiction to grant leave. That the proceedings were a nullity, and there was no jurisdiction retrospectively to grant leave. So you really have messed up if you bring proceedings in circumstances where leave is required, and you really may not know that this point is going to be taken. I mean, I have seen a number of cases where some ingenious lawyer acting for the police has essentially constructed a case that all of this was done in reliance on powers under the Mental Health Act, where on the face of the documents, nothing seems to be said about we used our powers under Section 136 or something like that. So it is something that you really do need to think about. And then the last bullet point now, I've said if leave's not sought, then the claim's a nullity. I said, since nobody else is covering 329, I will point out that if this is different here under the Mental Health Act from what happens under Section 329 of the Criminal Justice Act, where people may be familiar with the case of Dorian and Commissioner of Police. In that, if you need leave under Section 329 of the Criminal Justice Act, and since we've got no slide on this, that is a provision that means that if somebody has been convicted of an imprisonable offence arising out of the same facts on which you're trying to found your claim, that the statutory, you need permission from the court to bring the claim, and also the substantive law is altered essentially to one of, I think it's grossly disproportionate force or bad faith. So you get what might be, for instance, on an assault claim, you might get home if you can prove that unreasonable force was used. If you require leave under permission under Section 329, the substantive test or the threshold is moved to one of grossly disproportionate force. So in Dorian, the police had broken somebody's leg when they were arresting him in circumstances that seemed all a bit unconnected to the reason that he needed to be detained. And the court, decided that despite the fact that permission hadn't been sought, because it hadn't deliberately not been sought, but was a mistake, it was appropriate for the court to consider the need for permission on its merits, and it decided that it could grant it and grant it retrospectively. So if you're needing to deal with Section 329 and you forget about it, you might be in a better position than if you forget about applying for leave under the Mental Health Act, because in the latter case, the leave under the Mental Health Act, you really are screwed and you're in the same position as the unfortunate claimants without grant of probate and so on in the cases Sarah's been talking about. Now, I mean, this is perhaps beyond the scope of what we need to deal with tonight when we're looking at sort of how to avoid complete disasters and stuff. But it is an interesting argument about why bearing in mind the United Kingdom's obligations under the European Convention on Human Rights, a provision in relation to requiring leave before you can bring proceedings is still compliant with Article 5. Nobody seemed to argue any Article 14 points in SEAL. And as I've said, I've mentioned this, I won't read the second bullet point because I've mentioned that already. It may well be that it's not apparent to you until the defence or response or whatever is served in your claim that you realise you needed leave. One argument that I didn't think was particularly well considered in SEAL is the fact that for a false imprisonment claim, the burden of proof rests on the detainer. So how is that reconciled with being Article 5, with the requirement of leave, with the Article 5 requirement of legal certainty, the Article 5 requirement that the burden rests, that the state justifies the detention, and the Article 6 responsibilities in relation to access to the courts. But that's an all very interesting case that might one day be taken to the Supreme Court, but we're not going to worry about that because we're going to apply for leave and get it right. So I'll move to the next slide. What is the threshold for grant of leave? The case of Winch and Jones, which is now nearly 50 years old, no, it's not, nearly 40 years old, it was a claim for judicial review, and there were arguments about whether about how all of this applied and whether in fact this was another example of somebody who was acting for the hospital trying to say that the claimant ought to get leave to act against the hospital. So a number of things are discussed. But why we want to look at it is because it shows us what the threshold is. One of the various dicta in the case is the test being one of reasonable suspicion that there's been a failure to exercise reasonable care. They, in the course of their discussions, say that the threshold is lower than the test for judicial review. And pausing there, in those days, applications for leave for judicial review. Sorry, I've misput my bullet point. I should have put the threshold is lower than the test for permission to apply for judicial review. And bear in mind that in those days, the test for permission to apply for judicial review, or the degree of consideration that the court gave it, was quite a bit less, because these were all ex parte applications and the sort of 20-minute or so argument in court, normally with only one side there. So if the test was set lower than that, it is still a low test. And that's why we get to what I put on the last bullet, or the second last bullet point there, on the material immediately available to the court, which can of course include material from the proposed defendant. The applicant's complaint deserves the fuller investigation, which would be possible if you're allowed to proceed. And that test was approved in Winch and Jones, and I've set out various dicta from Winch and Jones to show this. A very unexacting level, says Lord Bingham, or Lord Simon Brown, whether the case deserves further investigation or deserves to be addressed at the trial of the claim. Now, there is a slight potential gloss on that, and I've set out a recent case that I was involved in, a case called Upadastra, because there is some court of appeal authority that sort of looks at having reasonable prospects of success and so on, but nobody seems to have said in that case, well, hang on, there is binding authority from the House of Lords in the case of Seal that this is the test. So personally, I'd be happy if I was setting it at a very unexacting level, though of course, thinking ahead to anticipate Stephen's talk, if all you've got is material that will satisfy a threshold at a very unexacting level, you might wonder whether you want to pursue the case beyond that, whether you're going to win. But anyway, that's the test. Now the procedure, I said Upadrasta, lots went wrong. And what had happened in Upadrasta is, first of all, the claim had been brought without seeking leave, and it had all got struck out and they had to start again. And then the second time it went in, the claim form or the application was made to a master and requesting a hearing. And what in fact happened was that the master simply granted leave without hearing any more from the other side, whatever, and the other side kicked off about it and complained and all of this sort of stuff. And we'll come back to that in a moment. But and we'll see that at the bottom of the bullet point, because one other error in Upadrasta is that, in fact, 139, it requires the leave of the High Court, not a master, and I'll take you to the slide on that in a moment. But one thing to bear in mind, unlike Sarah's talk where people are agreeing limitation extensions and all of this sort of thing, that won't do here. You actually have to have a court order granting leave. So how I would try and suggest you pursue it is that you indicate in your letter of claim that you would need leave from the High Court, and you'd invite the other side's agreement to sign a consent order. Now, if they do that, that you still haven't got leave, because the order itself has to be approved by the court, and that is something from a recent case that I've been in, a case called Croc. I mean, we didn't fall foul of that, but it's just that is authority for that proposition. What we were doing in Croc was getting our costs for arguing or for having to have an argument all about this when they should have consented. But that's the reference. If they don't agree, then you're going to need to apply to the court for leave. And you apply using an application notice. You want to put some information in about the case so that you can show that the unexacting threshold will be satisfied. I would have a witness statement from you, the solicitor, some relevant pre-issue correspondence. You may want a skeleton argument, and sometimes you might want to have draft particulars of claim, because of course if you've got draft particulars of claim, you are setting out what your case is, and it may make it easier for a judge to assess whether you are going to meet the test for leave. I would try and send all of this to the defendant beforehand to try and get them to agree your consent order. And if they're playing ball, then perhaps the appropriate costs order is costs in the case. In fact, Croc says that it would be. But if they've refused to consent, then I think it's time to get a bit more bullish on your costs and apply for the costs of arguing about it, as we'll see in a moment. So I said that it's only a judge of the High Court that can exercise this jurisdiction. That is a point that was considered in Upadrasta and luckily was able to be corrected. But it is clear from the practice, it's only clear when you drill down into lots of obscure practice directions that you'd probably never bother reading the rest of the time. I mean, you can see it's PD2B3.1G, a provision that I'm not immediately familiar with, that shows that it's that excludes the master from exercising the jurisdiction of the High Court, which the master has in other circumstances. As it happens, and here I said I distinguish it from 329 applications, if you're seeking permission to bring a claim under Section 329 of the Criminal Justice Act, you can apply to a master. And that is one of the reasons that the solicitor had got it wrong in Upadrasta, because they thought, well, it's the same sort of thing, and they assumed that it would be all right, as in fact had the master, because the master had granted leave. So it wasn't exactly something that was obvious and everybody should know, but it can cause difficulty and did cause difficulty in Upadrasta. I've then said you want to be saying that you invite them to make the order on the papers. And of course, again, you may be up against the clock. If you've got a case under the Human Rights Act where you've got a 1-year time limit, you may well be needing to make sure that the court has time to deal with all this. And exactly that problem arose in Croc and Chief Constable of Norfolk, where the solicitor was basically having to, the judge who was supposed to be dealing with the case had sat on it for a bit, and the solicitor was having to sort of make urgent applications to another High Court judge simply to grant leave so that the case could be filed within the issued within the limitation period. I don't think I need to spend long on this slide. I think I've covered most of it along the way. I've given you some references to what you might benefit from if people have argued the toss about costs. So I'll move to the next slide. Once you've got leave, then you have to serve it. And that's again another problem that had arisen in Upadrasta. You would need, I would have thought, to show the court when you issue your claim form that you have leave. So you need to put your order in with your order granting leave in with the papers, and then you can get on with it. Now, as I've said, there will be some cases where the substantive law is affected by, because instead of it being sufficient merely to show that somebody was detained, say, and that the burden of proof now rests on the detainer, it may well be that the test of bad faith or without reasonable care arises. So to give one example, the police detaining people under their powers under section 136 of the Mental Health Act, where they have a power to detain and remove to a place of safety somebody who appears to them to be suffering from a mental disorder. Now, on the face of it, with most claims that we bring against the police, we say, aha, he was detained, it's for you to justify the detention. And that either their reasons are good reasons or they're not. It may well be the case that you have to show absence of reasonable care or bad faith in the use of a 136. I don't think there's a case that actually says that, but it is something to think about. I suppose in reality, most of the time, if we're bringing cases where we're saying that section 136 has not been lawfully used, we would be able to satisfy that hurdle. We would be able to say, well, they should have taken more care over it, or they should have done X or should have done Y. Upadrasta is in fact a case where somebody is removed from his own home, purportedly. Well, there's an argument about where he was, but basically the police turn up at somebody's home and remove him when they are, because they've had information that he's left some concerning information with his social worker that he was about to damage and harm himself and so on. And part of the issue there is whether in fact he had been in his home at the time, and because then it's not a public place and all this sort of stuff. And there may well be arguments in that case on whether it's sufficient merely for the police to have detained him and then to have to make out all of their burden, all of their defence, or whether in fact it's sufficient to, or whether in fact the claimant needs to show this was without reasonable care. But that remains to be seen. I doubt that in fact we will ever get a fully definitive judgment in that case, but that's for reasons that lie down the track. Unless, I think that's probably as much as I wanted to say. I hope I've covered as much as anybody wanted to know about section 329. People can of course ask questions later, although bear in mind that any questions and any answers are being filmed.
And also taking up time for the drinks and food.
Exactly, well yes, it is Friday night, so there we are. Thank you very much.
Thank you.
Yes, well, on the subject of taking up time between now and drinks and Chateau Garden Court's finest, I'll be dealing with the new fixed recoverable cost regime. Apologies to all of you who had to hear me give this talk, I think on 94 of doing this over the last 6 years. But I have, now that the regime has come in, try and deal with as much kind of cross-sector stuff. Because previously I've been largely dealing with inquest costs, police costs, and I'd rather actually give you a bit more of an idea of, in the diverse number of claims which fall within FRC on its face, so we don't have a clear exemption, what can you do in terms of coming up with some good arguments on allocation to put the defendant back in their box, and actually some arguments which might win if you have the misfortune to go to any cost hearings. So just to kind of recap, we had, after many years of being threatened, the statutory instrument for fixed recoverable costs finally being published in May earlier this year, where the Ministry of Justice and the Civil Procedure Rules Committee reverted back to, in large part, Rupert Jackson's original recommendations that he made in 2017. So there is now, in between the fast track and the multi-track, the new intermediate track And the idea is that it's not just about controlling costs, but there is an entire set of procedure rules that you are confined by. So it is that fixed costs will be just and proportionate if you fit within the procedural framework and the much more limited and restricted scope of the intermediate track. Implementation day was on the 1st of October, earlier this month. And the idea is that, subject to the exemptions are going to come on, it covers everything from £25,000 to £100,000, so very significant. And in reality, unless you have psychiatric injury with a loss of earnings claim, almost every kind of case that you will experience within the claims against state detention, due to the historically low rates that we have, particularly in relation to false imprisonment, where even on a very lengthy period, you are just licking your finger and seeing which way the wind is blowing in the High Court. Now, there is a qualification to all of this, which is that some of you may know the Association of Personal Injury Lawyers issued a judicial review, which was stayed pending consultation. That consultation has happened, closed, and a promise of draft rules to amend the FRC rules was promised to come into force in April next year, but they haven't published it and have given no indication about what's going to happen. I've been trying to find if the APIL JR has been unstayed, but I haven't been able to get to the bottom of it. There's also been a series of representations to the Police Action Lawyers Group that the exemption for police cases will be expanded to all public authorities, or at least some kind of variation on it. But the last communication we've had about that was, well, we're going to do it by December at the very latest, don't you worry. The difficulty is that the Civil Procedure Rules Committee has now met. It's the last meeting of the year before they can bring this in is December, and they still haven't communicated a draft rule. So it's a bit up in the air for the time being, but there are potential for developments coming up in the near future. So just to give you an idea of, is it actually something you should be worried about, I've done the rough calculations to give you an idea of what you'd be talking about in terms of your fixed costs. And for our kind of work, I don't think you need to be worried about band 1, band 2, it's band 3 and band 4, which are the two higher levels of complexity you need to be worried about. Save for some exemptions. When you look at the grid in the practice direction, you may think, oh, you add up the band stage 3, stage 4, stage 5, stage 6 figures. They're actually cumulative. So this figure is for everything apart from counsel advising in conference, settling a statement of case, or giving post-defence advice. You are looking at £29,000 plus 22% of damages. So really, actually, even at your best level, I've taken £20,000 damages as your kind of best case scenario, but of course, many of our cases, even in a case of assault and low-level personal injury, are going to be below that false imprisonment, although don't worry about false imprisonment too much. But you're talking about £33,400 for solicitor costs. I've given you the extracts in terms of, don't worry, council's not exactly looking at a huge amount of money either, not least because council's work is very clearly defined for specific tasks. Anything additional to that will, I'm afraid, have to be folded into your overall trial costs. So if, for example, you want me to review witness statements and give advice on witness statements in an FRC case, that is going to be folded into the overall banding that you see there in the overall figure. It's just for those specific pieces of work. Now, there are additional fees for trial, different fees for any case where you've got protected party or infant settlement that I haven't extracted, but those obviously take place under a very different regime. The answer is you are not going to be able to run most of the cases in our area under that regime. And it's worth underscoring that was the conclusion of Rupert Jackson in 2017, because we submitted a huge amount of cost budget data. And if you looked at even relatively straightforward litigation in this field, you were talking about £54,000 to £60,000, and then obviously up to in excess of £200,000 or more. That data was so distortive of the level of fixed recoverable costs and trying to calculate it for the sum, that when Sir Rupert came up with the grid that this is an updated version of, he said, I have excluded all of the Police Action Lawyers Group data, which, although it is called PAL, did include state detention claims and other actually much more broader claims than just state detention. And just to give you an idea in terms of how those complexity bands are defined, they are, as you can see here, they're all done in relation to personal injury. The exceptions are actually in relation to debt claims, but it is very much focused and very much orientated around personal injury claims. or RTA, and the other aspects that you would ordinarily expect to see in day-to-day personal injury litigation. Again, not the kind of issues you would expect to see in even the more straightforward areas of our work. So what can you do to avoid it? Well, the first thing is be very much across the exemptions and actually what falls within FRC in the first place, because actually it's a relatively generous transitional provision, and really you want to be focusing on paragraph 2.2a, which is a claim which includes a claim for personal injuries. Note B, if it's pure personal injury alone, then it's only where you haven't sent the letter of claim. But if it's a claim for personal injury, so a mixed claim involving more than one head, so you've got damages, but you also, for example, claiming damages under some other head, loss of liberty would be the usual one to go for, but that doesn't quite work in this case. But it's going to be a relatively broad heading. So if you're able to fit within that category, so you've got damages for reputation, aggravated damages would be something which I think would actually probably put you into that category as well. It means that you're only dealing it where the cause of action itself is accrued on or after the 1st of October 2023. And the advantage of fitting into that category is, of course, if the Civil Procedural Rules Committee follow through on the representations they make to us, you should hopefully get your case past the point at which we will have the amendments and have a much broader definition of exemptions for claims against public authorities. But it's also worth going through those cases which have bright line exclusions. I'm just going to run through the ones. They're all contained in CPR 26.9. The first category is this one, a claim for damages in relation to harm, abuse or neglect of children or vulnerable adults. Which on its face, I know there's been a lot of discussion about this actually being quite a broad exemption. It is actually a repetition of something that has already existed for a number of years in respect of employers' liability and public liability under the low value personal injury protocol. There hasn't been a huge amount of case law on it, save for Scott, which I'll discuss in just a moment. But it's worth emphasising that in terms of that first part, harm, abuse or neglect, now harm obviously could be defined as much wider and as expansive enough to include all personal injuries. The argument that was run in Scott, and the Deputy Master in Scott was Mark Friston, who's the author of Friston on Cost, so he's not an unpersuasive authority, and indeed I believe he's just incorporated this wholesale into his book, which most of the cost judges will have open in front of them. But the argument is that harm is done by reference to abuse or neglect, and abuse or neglect requires more than just personal injury. So the definition of abuse is found in LASPO, and it means deliberate mistreatment, exploitation. It's something more than just you've suffered personal injury. Although the exploitation bit will be useful for any of you who are thinking about victims of trafficking in particular. But also there is the definition of vulnerable adults, which again is incorporating the LASPO criteria, looking at someone whose ability to protect himself or herself from abuse, so again linking it back into the LASPO definition of abuse, is significantly impaired through physical or mental disability or illness, through old age or otherwise. And it's the or otherwise provision that actually may be, and I've gone backwards and forwards about how restrictive the courts might be on this. There is going to be a huge amount of uncertainty on this. But in dealing with Scott, which was a case of a prison officer who was assaulted by a violent prisoner who was known to have made threats, said that the next officer who comes in through the door is going to get his nose broken. The argument there is, well, he's been injured. A prisoner of that type is a vulnerable adult, and therefore I shouldn't be restricted to fixed costs under the ELPL protocol. And what Deputy Master Friston said was, well, the definition of vulnerable adult is going to be highly context specific. It's going to vary based on the actual claim you're bringing. And someone may be, and you can see the, I have to say, slightly uncomfortably patronising example he's decided to choose here, but that someone might be a vulnerable person if it's a sexual abuse case in respect of her workplace, but not if it's because there's a slip and a trip in a supermarket. And it's worth emphasising it's in relation to. So it's not that necessarily it's direct. And a useful example, and I think working this through in my own head, thinking how can I fit a victim of trafficking who's claiming for Article 4 operational duty breach, fit within this definition? Well, someone who is a victim of trafficking is suffering harm, abuse, or neglect in the form of labour exploitation, sexual exploitation, and other forms of exploitation. It very readily fits the definition of abuse. They are significantly impaired, perhaps not due to mental illness, or, and I think these are the best cases to bring on this point, in conjunction with some form of mental illness, some form of psychological injury. But they are significantly impaired due to the disparity of power, the coercion and control, the other aspects which mean that they are not able to take steps to protect themselves. And they have threats against their family in their country of origin. They have experienced abuse at the hands of their employer in this country. Threats to, if you leave, I will report you to the police or otherwise, or threats about the status of the home, I'll report you to immigration, you'll be deported. Those kind of very common threat patterns. And it doesn't need to necessarily be against their exploiter. A claim against the Home Office to say that you failed to implement the Article 4 operational duty, the Article 4 investigative duty in respect to my client, is a claim for damages which is in relation to labour exploitation, sexual exploitation for someone who's a vulnerable adult. But the key message there is if you are making those arguments, it is untested, it is novel, and you must bear that in mind when bringing these claims. I think it's a good argument, it's something that you can certainly look at, but it's largely untested. And the approach of Deputy Master Friston was quite a highly technical analysis of the statutory language, down to, I would have expected that if harm meant something more than just personal injury, there should have been a comma in a different place kind of argument. Cost lawyers are highly technical people. They will take that kind of drafting point, be very much alive to it. But I think there are arguments to say it's broader. This provision was actually implemented as a result of the Association of Child Abuse Lawyers. And it's very much directed in order to address that issue. But I think there is some scope, I think Scott's a good example of the kind of case I would say don't bring. Don't, look for the good cases. And a message to say throughout all of this is be very careful about what you choose as your test case. We have bad experience in respect of Quox, where the initial cases taken were not attractive, and it has taken some 5 or 6 years to start getting good authority on mixed claims where there's personal injury as well as loss of liberty cases. How am I doing for time? I am blocking your red wine, I'm so sorry. Other exclusions, for anyone who does immigration, good news, you're out in terms of any of your immigration detention claims which are based on false imprisonment, because it's a relatively broad provision, it's any case or any cause of action that could be tried by jury. You don't have to make the application, you don't have to actually ask for a jury trial, it's just any where you could make that application, which means that it will be all cases of false imprisonment, all cases of malicious prosecution against anyone. So whether it's a private or state body, actually, it will cover you. Obviously, though, that in immigration detention, and I'll come back to this, obviously what it doesn't cover is any assaults by detention centre officers. It doesn't cover any of the other kind of causes of action that regularly crop up in detain centres. Article 5 claims for excessive curfews imposed by the Home Office, or anything that doesn't meet the false imprisonment threshold, but does meet a violation of Article 5. And this is the police exemption, and it's just worth, my view is paragraph 11 is entirely redundant because it doesn't fall within the scope of the actual exemption itself. 11 is really actually just demonstrating the extent to which throughout all of this, the Ministry of Justice really is quite obsessed with RTAs, slips and trips, and literally C is slips and trips in police premises, and otherwise employer liability claims. But it's about intentional reckless torts and relief or remedies in respect of HRA claims. And that is going to be useful for those of you who don't fall within the police exemption at the moment for saying, well, if we read the CPR as a whole, which is what you should be doing, not many of us do, not least because we don't delve into practice directions, as Mr. Simblet's already referred to. Some of us do, sometimes, when we need to. But if you use that, and this is what I'll come on to finally, is you can use that to say, well, look, this is the category that they have given a blanket exclusion from. We are closer to this because we're dealing with an allegation of a Human Rights Act breach. We're dealing with an intentional reckless tort. That the CPRC has certainly identified respective one should be subject to a blanket exclusion. So suppose you're not within those categories, you're trying to argue out of, so you're on allocation, what track should I go to? These are the definition of the procedure. So it's got to be a trial that will not last longer than 3 days. You've only got 2 experts per party in respect of oral expert evidence. Justly or proportionally managed under the procedure. That is, again, things which are very much focused around restricting the amount of witnesses, what you're doing, the kind of bare bones of the procedure. But the one that is going to be most useful for you is actually this last one, 4, which is that there are no additional factors which would make the claim inappropriate for the intermediate track. And that is an incredibly broad provision that your overall justice of the case, interest of justice arguments can be fit under. And that may actually give you some very good leverage for argument, whether it's post-settlement and you're arguing this on taxation, or whether you're pre-CCMC and you're going to have an argument about what track to be allocated to. But also note 26.8, it reverses the presumption. If you fit within those initial criteria, you have to try and argue, well, I should get out on an interest of justice basis. If you're asking for non-monetary relief, i.e. your declaration of the Human Rights Act, the burden is actually reversed. It's not going to be allocated to the intermediate track unless it is in the interest of justice to do so. So don't allow the defendant to try and put the burden on you to say why you go in. It's the other way around. They have to say why it's just for you to go in on the basis that you're actually seeking declaration, which you're entitled to, and it's an important part of your just satisfaction and your remedies under the Human Rights Act. Defendants can't keep going on that damages have a secondary role under the HRA, and then also use that to undermine your position in respect of declarations when it's convenient. They can't have it both ways. But if you are drafting something, what I recommend you do is read Wilkins and Serco, which is a recent case by Heather Williams. It was the wrap-up, and it's about the difference between allegation to the small claims track and the fast track. So it has some distinct arguments which you need to be careful about. It's actually got a rather interesting history because 2 of the best cost silks of the bar, Roger Mallew and PJ Kirby, having a very serious argument about allocation, but in large part building it on Maguire and Ministry of Justice, which was a GT Stewart case that Rachel Shern, who was then a pupil, did when she's now on the UCPI, gone on to a flourishing career. She did it as a pupil, but in large part they are building on her arguments. So Rachel Shern and Garden Court, to be clear, are better than 4 New Square and more cost practitioners. Apologies if they now watch this on YouTube. But it is funny to see something that was argued out and was a long-standing issue in PALG. Actually, in large part, it all built on that county court argument that we had in Maguire. And actually, it's very useful because Heather Williams, she doesn't quite say this is all right, but she says it was open to the cost judge to conclude that the reasoning was right. And it goes through in quite a lot of detail. A lot of it's about false imprisonment, but if you think about the kind of cases we're bringing, they're of universal application. So the fact that a particular cause of action isn't subject to an express exemption in the CPR doesn't mean that you can't take into account the wider importance of the cause of action, its constitutional nature, the fundamental importance of holding public authorities to account. The complexity of the law on liability and quantum are all relevant factors to take into account. You can see there 3 dealing with expressly that point that I just made. You're looking at not just what does it mean to this individual. Mr. Maguire and in fact Mr. Wilkins were both detained for about 3.5 days after the service of their sentence, and they passed the conditional release date. But you're actually looking at, well, what is the wider function of the tort? And also there again, in terms of 4, importance of the system, that those who are detaining, that court decisions affect a person's release, liberty and release from custody to be actioned on a timely basis. You can use that for all sorts of other systems arguments that we encounter on a regular basis. Think about the way in which unaccompanied asylum-seeking children often encounter issues with the Home Office or local authorities that you might be considering. Victims of trafficking likewise. Important systems that are regularly failing in operational ways and exposing those systemic failures. And the last 2 points are also useful. I mean, this was in a case where it was no costs, or at least some costs. We're not quite in that realm, obviously. But the last one is a particularly useful argument to make. These are areas where Parliament has decided to preserve legal aid in respect of them. And go back to those costs that I went at the beginning. On a lot of cases that you will be bringing, you will exceed on legal aid costs those very, very, very low figures. So your clients are going to be exposed to the statutory charge. And actually, Heather Williams was reasonably persuaded in Wilkins that actually the stat charge and undermining your client's damages in this field was actually a highly relevant consideration. So provided you can demonstrate that that's a relevant consideration on your particular case, you've got a relatively compelling argument that actually, no, we should be going over to the multi-track, because it wouldn't be just that in order to bring this claim, our client actually may have his entire damages wiped out by reason of the stat charge. And likewise, and this is the point I made about the police action exemption, what succeeded in both Maguire and Wilkins was, well, we may not have an express provision, but if you look at all of the other provisions, what kind of cases fall into the small claims track? What the practice direction said that, it's about product liability, washing machines that break within the period of their warranty, or other similar cases. False imprisonment in a prison bears no resemblance to those. It does bear resemblance to other cases, for example, the fact that Parliament has preserved a jury trial in respect of it. So make sure to say, well, actually, look at the police actions exemption. It's for all Human Rights Act claims against the police. It's for all reckless or intentional torts against the police. So if you are bringing a misfeasance claim against the Secretary of State for the Home Department, don't be ashamed of saying, well, there's an exemption for the police in respect of misfeasance in public office. Why should that be any different for the Secretary of State for the Home Department? That's your starting point, not that I should fall into fixed recoverable costs. Go for the broader contextual stuff that does exist within the CPR, and use all of these arguments together to say, well, actually, looking at everything and on the interests of justice, it's inappropriate for us to go into the FRC track. And there's my customary answer every time we discuss the topic. Are we all doomed and this area is going to become unviable? No, there's lots of reasons to think we are going to remain viable for the time being. As ever, with each passing year, it gets a bit more restricted, things become a bit more difficult, you have to come up with new arguments, but in large part, we should continue to be viable. We do have some good arguments. It's just about identifying which case to press these on, which ones to say, these facts perhaps not, but identifying the good cases to bring. And we will get good authorities such as Wilkins in the long run. I mean, that between Maguire and Wilkins was a passage of 6 years before we finally had authoritative guidance from the High Court on it. Some lunatic at Serco, G4S Mighty, will eventually take you all the way to the High Court. With the right barristers, for example, at the Chambers, you might actually stand a chance of winning. Thank you very much. We've got our Q&A section now, or straight on to drinks if you're sensible.
Very much, everyone on the panel. We do have some time for some questions, so I'll take one from online first of all, and this comes from Kelly at Farley's. The question is, out of interest, how are clients funding probate? Has anyone seen this fall under legal aid, or are clients bearing the cost, or are firms taking on risk hoping to recover at the end of the civil claim?
As I understand it, there was something that went around in PAL not so long ago about legal aid being available for probate claims when you're looking at claims under £5,000 or so. I think the difficulty arises when you have solicitors who are looking to represent claimants who aren't probate solicitors, because I think you're restricted then to actually giving some advice or assistance, but you can't actually do the litigation around that if there is an issue about probate. So I think you're restricted to maybe seeking counsel's advice or helping with the forms. I know some solicitors will help with the forms to the extent that they will populate the form as far as possible, then sit with the client and get them to fill in the rest, sign it. But it's often easier, I think, if the claimant can do it themselves. It's a matter of just writing to the probate office, filling out the PA1 form, and them doing it without getting involved in the litigation. Advise them as far as you can, but I don't think there's legal aid beyond that.
What about the situation where you, as is contemplated in your paper, where you've got a number of potential claimants for your Human Rights Act claim, and in a sense, somebody is going to act as administrator, but a number of other people are going to be within the contemplation of the claim. Does that make any difference to any of that? I mean, does it make a difference as to who? It's sufficient if just one person applies, but if somebody's got it, you can just get on that, so that's fine. Okay.
Yeah, and obviously it doesn't affect the legal aid that you would get in terms of a Human Rights Act claim anyway. But I think, was the question specifically in relation to getting probate in place? Or?
Yeah, well, specifically about funding probate and how it can be funded. I think in my cases, I think it's been paid for by the clients themselves in each case.
Right, yeah. Yeah.
I'm not aware. I don't know if anyone here has managed to secure legal aid that's paid for funding of probate. No, I'm seeing shaking of heads. Yeah, I think the answer is that upfront payment, because there is an upfront payment to be made. I think is mostly being made by the clients. So, in a lot of cases, people will want to know before. If the only reason for applying for probate is to bring the civil claim, they will want to know, well, before I pay this money, have I got a viable civil claim? And sometimes you're applying for probate before you know whether the civil claim is viable. And then there are other considerations as well, because if somebody applies for probate and then the estate, the deceased person had significant debts, there are things to think about there. And so that those are the sorts of questions, but I appreciate what you're saying, Sarah, about if the solicitor acting is not a probate lawyer, they are limited in what they can do.
I know some solicitors will help in as much as they give basic advice, but then direct to a proper certified probate solicitor.
Yeah, but then that probably has to be paid for as well. Are there any questions in the room? Yeah.
I had a couple actually for Sarah as well. But by all means, just answer the first if everyone wants to get to drinks. But first one was, you mentioned that indirect victims can bring Article 2 claims on their own account. Is that in relation to breaches of, say, the investigative duty that's linked into Article 2, which you can see would be owed to not the deceased, but to those who survived them? Is it for breaches of only those aspects of Article 2, or can they bring a claim under Article 2 in relation to the death itself, perhaps because of the harm, emotional harm caused to them?
Yeah, I think the cases I've been involved with have normally been the indirect victims of a loss of a loved one, and it's that breach of Article 2, that breach to life, the loss of the life. In terms of the investigative failures, you mean post-death?
Yeah.
So there's been a death, police have failed to investigate that properly, for instance, and the family are looking at bringing a claim for that breach. I suppose that would emanate again from the estate itself. So you'd have a claim brought in the deceased's own name, the estate's standing of the estate. Whether they would, I don't know, would you say, have you had experience of that? I don't.
Yes. So
you have?
When you take the case to Strasbourg, they in particularly in respect of Russia, Turkey, Ukrainian cases, you will often find that there is both a violation of the operational duty and a violation of the investigative duty as well, usually on independence, effectiveness, or something else that compromises it. It's a very specific development of the jurisprudence that really only exists in respect of Article 2. It does exist, and it's based on the
Article 3
and Article 3 in respect of disappearances.
And Mercurial.
Yes, exactly. It hasn't really been developed much beyond that in respect of others, where you might, and I think there's been more recent jurisprudence in respect of Article 8 and attempts to argue it through that route. And it's based on the anguish and distress that those breaches cause the family, which is what you get your just satisfaction damages for. And Strasbourg's used all sorts of different phrases over the years, anguish and distress, grief and suffering, and other forms of the language, that you can bring it on behalf of the estate, or you can bring it on as in your own right, so to speak. And Strasbourg generally takes a broader view than, it doesn't require you, and there's lots of jurisprudence to say you don't need letters of administration. It's not done by the domestic law. Do you meet the criteria as the next of kin? It's a much broader contextual analysis to enable the rights to be practical and effective.
That's an example of Stephen's point about litigating cases on good facts, because the propensity of the Russian, Turkish and Ukrainian governments to not get to operate entirely oppressive legal systems and then fight all these cases or take no part in them when they go to Strasbourg means that those sorts of principles are established on obviously very extreme and serious facts, where anyone would think, well, some sort of investigation is necessary if someone's been, in one of the cases they dumped the bloke's body on his family's doorstep or something, and then you might think some form of investigation is in order, but the Turkish government didn't. So therefore the sort of facts are and the principle is established on very extreme facts, but it will benefit us here. Now on a rather smaller scale cottage industry basis, these arguments about costs and so on. That's why it's important to have proper cases, not people who've slipped on a grape in a supermarket.
If I'm allowed the part two, it was just whether you've heard of applications to court for grants of letters of administration. Say you're staring at that 16-week time lag that the probate registry take, and you need a grant quicker. I've heard from other practitioners that you can apply to court for a grant of probate directly from a High Court master. Have you ever come across that?
I haven't, but I know that provided you get grant of probate in place before trial, it shouldn't prevent you from issuing the claim, and that's the Jennison case. But in terms of getting it from a master, I think
you must be able to do something like that. But I mean, it's just, it may well be that a lot of these cases get resolved as the way Sarah said, that you explain the difficulty to the defendant, who won't want to be paying the costs of your urgent application to some High Court master membership.
And it's not as detrimental as the failure to get letters of administration. So you would get letters of administration, whether you'd be able to get those through. I think you have to apply for those.
I mean, these cases are very difficult because very often you've got somebody who's got, there may be relatives that you don't know about, or that the person from whom you've been taking instructions doesn't know. And I had a case where somebody had a son in America that the family had literally never had anything. We had to include him on the as one of the people in the Human Rights Act claim, or you get people whose main family are based abroad, and all. It's the practical problems in bringing these cases are very significant, and yet for all the reasons Stephen's been saying, you may well end up in circumstances where you're dealing with fixed recoverable costs. It's just
sometimes I know there's a case where a solicitor put names on a claim form and issued for claimants that he knew existed, or potential claimants, even without getting their agreement first. And although it might be seen that might be seen as a really negligent thing to do, but it wasn't criticised by the court, because that could be amended by taking them off later. Obviously, with
you have to have somebody from whom you've got instructions.
Oh yeah, like an initial claimant. So you have the initial claimant, and you claim it on behalf of the estate, and it's known that there are some other potential claimants elsewhere. You can't get hold of them for whatever reason. Put them on the claim form, make it clear that this is the reason why you're doing it, and be all upfront about it. And it may be that eventually you get hold of them and say, no, I'm not interested, I don't want any part of it, and so you just remove their name from the claim form. But at least you've initially, put that out there, that there are some potential others as well.
There's a case called Mooson on legal personality, which we used in arguing in some of those persons unknown injunction cases, where the woman issued a claim on behalf of herself, her children, without a litigation friend, and her dog. And the judge was quite critical of that, but we probably don't need to go that far in these sorts of cases.
Thank you. There's another question that's come in online, which is, what happens if the claimant dies mid-action, e.g. having instructed an appeal, but before the appeal is filed? I can probably answer this one a bit. So the first thing that you would need to consider is whether you have sufficient instructions on the information available to you. If you have any detailed attendance notes, if you have any signed particulars of claim or whatever it might be, if you have a draft witness statement, do you have sufficient instructions to carry on is the first question. Second, you'll need to try to identify if there is somebody who is willing and able to continue the litigation on, and the way that they would need to do it is by applying for letters of administration, and then they would continue the claim on under the Law Reform Miscellaneous Provisions Act. So if it is a legal aid case initially, you will ideally want to identify someone who qualifies for legal aid, who is willing and able to take the case on. And it may be that there just isn't anybody who is willing to bear that risk, or it may be you don't have sufficient instructions, and it may be that the case has to come to an end. So that those are some of the questions that you'll want to ask yourself in those circumstances. Does anyone want to add anything to that?
And then there's you make an application under CPR 19 to substitute the estate, and it is technically possible to do so in the absence of letters of administration or a grant of probate, but in very defined circumstances. But CPR 19 is where you need to go once you've gone through those initial steps.
Thank you.
The difference is that the claim's already
Yes, it's
properly
already
issued.
Yes,
So this isn't a
precisely.
dead in the water claim that should never have been brought in the first place. There was a proper claimant that brought it legitimately and distinguishable.
And all these online people, they've got their drinks at home, aren't they?
There's one comment, just a quick thank you, very useful and interesting, so I'll read that out. Any more questions in the room? No?
Well, we may not be doomed.
But of course, if you have any further questions, then of course you can ask them over a drink.
Yeah. Thank you, everyone.